Colbert, complaint 19-480-1214. Could I have appearance of counsel?
Good morning, Your Honor. Jody Carbone, Assistant Prosecutor on behalf of the state.
Good morning, Your Honor. Edward Cridge of Melco O'Neill, Hopewell, New Jersey, on behalf of Eugene Colbert, sitting to my left.
All right, I understand this is a detention hearing, so Ms. Carbone, let me hear you on the issue of probable cause.
Thank you, Your Honor. The defendant is charged with first-degree aggravated sexual assault, aggravated criminal sexual contact, and endangering the welfare of a child. The victim reported on March 9th of 2018 that from a time period beginning in November of 2018 through March of 2019, specifically March 5th of 2019, the defendant engaged in a sexual relationship with her. It started with him sending her pictures on Instagram of his genitalia and then requesting and her sending photos of her intimate parts as well. It then progressed and to oral sex on 2 occasions, digital penetration on 3 occasions, and vaginal penile penetration, and also sexual contact. What's alarming about this instance is that it is a first degree because he is the coach of sports teams and a paraprofessional at her school. And this is a 13-year-old child. This happened during the hours of school. He used his keys to unlock storage rooms and trailers to give access to the place where these assault instances occurred. In terms of corroboration, the state has obtained surveillance video of the defendant and the victim going into the store, into the equipment locker room, facility, storage room, whatever you want to call it, on multiple occasions that corroborate her statement. Additionally, the matter initially came to light because at least 2 employees of the school reported it to their superiors because they believed that what they were witnessing was an inappropriate relationship between the child and the coach. In addition to the surveillance video of the sports equipment room, there is also surveillance video of the March 5th incident of the vaginal penile penetration, not of the actual act, but of the defendant unlocking the trailer and bringing the victim in there for 45-plus minutes. In addition to the surveillance video, there's also surveillance video corroborating the child's statement where she reports that on Valentine's Day, the defendant gave her Valentine's presents, including a large stuffed Valentine's bear. The surveillance video also shows that as well. There are phone records that have been obtained that do not show the contact between the content of the contact between the defendant and the victim, but do show extensive phone and text message communications between the defendant and the victim during that November through March time period. Additionally, and most telling is a 4C intercept where the victim contacts the defendant, tells him that she is concerned, she believes that she may be pregnant, and he asks her when is she due to get her period. Again, this is a 13-year-old child. He questions her as to whether or not she's looking for a confession, insinuating that there would be one to give, while he does not acknowledge while he does not acknowledge the extent of the penetration, there is acknowledgement that there was an amount of penile penetration, certainly sufficient to satisfy the statute. Additionally, Your Honor, and I'll talk about this a little bit later, he also acknowledges during that 4C, that communication, that he deleted pictures from his phone, and he continuously asks the victim and I'll submit with regards to that, Your Honor.
Okay, Mr. Christian?
Oh, and I'm sorry, one last thing. He does also, in that 4C intercept, acknowledge that he knew that law enforcement was investigating the locker room equipment area, but that they, quote, didn't know anything about the trailer where the penetration did occur.
All right, Mr. Christian, let me hear you on probable cause.
Thank you. Your Honor, I have had the opportunity to review the materials referenced by the prosecutor, including the statement of the alleged victim made to police. I would just note that prior to being interviewed by police, the alleged victim was interviewed by school district personnel, wherein she denied any inappropriate conduct occurring between her and Mr. Colbert. I've also seen the referenced surveillance videos, Your Honor. The door to this equipment room is open. In many of them, there are some other people who go in and out from time to time, but it's a wide open door on a school hallway. It is impossible, at least from what I reviewed, to determine whether there could have been other people in the room, and again, people do go in and out. With respect to the video from the trailers, this is an outside video. It simply depicts 2 rows of school buildings. It's impossible to determine, based on my review of that video, whether there are other people in the room in question, whether there are other doorways, etc. So, that's what my review indicated. I've also had the opportunity to review the wiretap reference.
4C, not a wiretap.
I'm sorry, Judge. The 4C that is referenced by the state here. I would disagree with counsel that that the person speaking on that 4C admitted to penetration. I don't think it's clear based on.
They're talking about sex, though.
Judge, the male person speaking on that repeatedly denies engaging in sexual conduct with the alleged victim.
Why would that person be concerned about the victim becoming pregnant?
It's problematic, Your Honor.
That's a good way of putting it.
Judge, more importantly, on this 4C, the male speaking repeatedly references the fact that he is potentially under investigation, and even that he could be facing significant jail time. And yet, Mr. Colbert, at least, did not run. So if the state wants to rely on the 4C in support of any argument vis-a-vis the likelihood of conviction, I think the state would also have to acknowledge that the 4C demonstrates that whoever was speaking on it, or allegedly Mr. Colbert, is not going anywhere. And I think that's an important point from our perspective to take from this 4C.
Court finds that there is more than ample probable cause here for all the charges, including the first-degree aggravated sexual assault with a victim under the age of 13, aggravated sexual contact, sexual assault with a victim between the ages of 13 and 15, criminal sexual contact, and endangering sexual contact. All right. Having found probable cause, Ms. Carbone, why should Mr. Colbert be detained?
Thank you, Your Honor. Your Honor, the PSI is a 2-2, no release recommended. The state submits that this is a very bold crime. This took place on school grounds during school hours, and he was in a position of public trust. So to say that while this may be the first victim, there's definitely a concern about public safety. Additionally, the 4C goes even further. In that 4C, the defendant says that he has 2 job interviews out of state. He also admits that he deleted the phone evidence, or the evidence on the phone, as I indicated earlier regarding the photographs. But what's really alarming is that he really pleads with this child to have his mother, the defendant's mother, speak with the victim's mother. Now, the victim, as indicated, I just want to talk about the school investigation.
Right.
It's alarming, it's concerning, and the Middlesex County Prosecutor's Office is concerned about the fact that law enforcement was not immediately called when these allegations came to light. In fact, there would have been probably would have been more corroborative evidence had the state been, these allegations came to light within the 5-day period where there would have potentially been DNA evidence. But I will say that the child was interviewed where she has this denial without her mother. The mother was called and she was unable because of her work schedule to come and give a statement. So the mother has, since the arrest, gone to the New Brunswick Police Department on a report on March 21st. She was walking around her block where she has a young child, but without those details. It was near her home. Also, the defendant dropped off a sweater to the victim's home after the March 5th incident because she had left a sweater in the trailer. And so he brings he knows where she lives. And after the arrest and all of these allegations come to light, the mother reports to the New Brunswick Police Department that while she was near her home with her children, an unknown male passed her as she was approaching the intersection of the corner right by her house. She describes the man as a black male, average build, with a beard, wearing a black jacket, black hat, gray sweatpants. The unknown male passed very close by her with the front-facing camera, so he was on a FaceTime app, had his phone out like this. The front-facing camera was activated. It appeared as if he was FaceTiming with another unknown individual. While coming into close proximity to her, the unknown male stated, quote, "I think that's the girl's mother." And at this point, the unknown male paused next to her, pointed the camera directly at her, and said to the person on the other end of the video call, "Is this the girl's mother?" And at this time, she then was able to leave and get out of the site of that person. This, in conjunction with the 4C, where the defendant is pleading with the child, trying to convince the child to speak, have the mothers speak, is alarming and concerns the state that there is potential witness tampering at the direction at the defendant. I would ask. No, I'll save that for the end, Your Honor.
Mr. Craig, why should I not detain Mr. Colbert?
Thank you. Your Honor, we're aware of the fact that these are very serious charges. However, our legislature did not apply a presumption of incarceration even to this very serious charge. The court's certainly well aware of the standard. Judge, the first issue is whether only detention would reasonably assure Mr. Colbert's appearance at trial.
And safety of the community.
I understand, Judge.
And non-obstruction of justice, which has now been put in play here.
Understood, Your Honor. I would address them seriatim if I may.
Okay.
Thank you, Judge. So the first issue is to reasonably assure his appearance at trial. Again, the state relies on this 4C, wherein the person speaking, and Judge, I will paraphrase from it here, said, "Even if I'm found guilty and I go to jail for 6 to 10 years, I want you to know I'll be the same person." So that's someone who is acknowledging the possibility of facing jail time. And yet, Mr. Colbert, again, did not run.
Did he have out-of-state interviews, as alleged by the state?
Your Honor, I have not discussed that with him. I don't have that in my notes. But these are not a transcription. Obviously, Judge, even if Your Honor releases him, he's been all over the news. He's not getting hired anywhere. Certainly, I don't think that there's any concern arising that he would be able to find employment out of state under these circumstances. Judge, additionally, Mr. Colbert was suspended from his position with the New Brunswick schools and given notice of termination a week or two at least before he was arrested. Suspended a week or two at least, and several days, I believe, was the timeline for the termination. So the bottom line is this is someone who knows that they are under investigation. He interviewed and cooperated with the school district's investigation. He met with them. If this was someone who was looking to run, it's not like he was unaware that he was being looked into.
You can move on from the he's not going to flee argument.
Understood, Judge. Your Honor, since he's been arrested, I have had multiple conversations with his family members, including his mother, Jeannie, including his half-brother, Milton, and I can make the following proffer to the court based on those conversations. And Judge, I would note that they are here in the courtroom today, along with a number of other family members and community supporters of Mr. Colbert. Mr. Colbert grew up in Middlesex County. He went through the New Brunswick school system. He graduated from New Brunswick High School. Besides attending Morris College in South Carolina, he has otherwise been a lifelong resident of Middlesex County. For the last several years, he has been employed in one capacity or another by the New Brunswick Public Schools, most recently as a paraprofessional, before that as a long-term substitute teacher, and he has held other various part-time employment over the years as well. He has also served as a coach. For about the last 18 months, Mr. Colbert has lived with his mother in, I believe it's Forked River, Middlesex County. His mother...
Forked River is not in Middlesex County.
Judge, I apologize, it's South River. His mother, Jeannie, is on disability. Mr. Colbert provides financial and other assistance to her.
Well, that's been cut off according to you.
It has, Your Honor. He's been terminated from his position, but he's up until the time of his arrest, that was his living situation. Several years ago, Your Honor, Mr. Colbert served as a foster parent for a period of about 2 years to no less than 4 of his nieces and nephews. Up until this arrest, Your Honor, Mr. Colbert was a sober, employed, responsible, upstanding member of the community. Additionally, he has recently done work with the Civic League of Greater New Brunswick, and again, he has broad support both from family and community members, as is indicated by the presence in the courtroom. Your Honor, moving on to danger in the community, and again, we recognize that these are extremely serious charges. The allegations here rose from a very defined, specific setting. That Mr. Colbert had the means and opportunity to foster and develop a relationship with a student. Though that means and those opportunity no longer exist for him. He's been terminated. He's not in the school. This is not, for example, a situation where there's been a random attack, a street attack or an attack in the mall.
So this is not a one-off either. This is not a one-time incident. This is an incident that apparently took place extensively over a 5-month period.
Correct, Your Honor, but with respect to the issue of danger in the community, I would submit that where the means and opportunity of this alleged...
You're suggesting he would only do this to school children, that he has under his control, that only every other child in the community is safe from it?
Your Honor, based on the nature of the alleged offense, where the opportunity is no longer present, I think it is distinguishable from a case where, where the modus operandi was different, where it was random, where it was not situational, as alleged here. Your Honor, additionally, and this is based on the statement which the victim gave to police, there is no allegation here that Mr. Colbert used physical violence, physical force.
That makes a difference?
For purposes of determining, Your Honor, whether there is a danger to the community that can only be satisfied by his incarceration, I would submit that it does. The alleged victim stated to police that he had never threatened her, either in order to accomplish any criminal act or in an effort to cover up any criminal act. He never threatened her in any way. And again, that certainly goes to whether or not there's a danger to the community. I was apprised this morning, Judge, of the concern about an unknown male asking, is this the girl's mother? Certainly my client was incarcerated on March the 21st. If he had communicated to someone that he wanted something done, that would have been recorded by the jail, and police would have been notified. So in the absence of any indication whatsoever that my client had anything to do with that, when certainly such an indication...
Well, there's people in the community that might feel that they want to defend this guy, and so that's a problem for the court. If his community support crosses the line into intimidation and harassment,
I
that undercuts his community support argument.
I understand the concern, Your Honor, but if someone has done something inappropriate over which the defendant had no knowledge and no control, I would submit that cannot be held against him.
No, I'm only holding against him his deletion of photographs and other obstructive activity, as alleged by the prosecutor.
Moving on to that, Your Honor, I would submit that in undertaking your analysis, the focus here should be on the potential for the defendant to obstruct justice in the future.
What about past obstructive behavior? I'm not supposed to take that into account as consciousness of guilt?
Well, Your Honor, if past...
And what he's willing to do in order to avoid and evade being charged?
Your Honor, then I think we have to look at capability. The state has subpoenaed records from, I believe it's Facebook. Facebook owns Instagram. The allegation is that there were inappropriate messages exchanged. Mr. Colbert certainly has no control over the servers of Facebook or the phone records of Verizon or the data.
Well, the allegation is that he deleted his own stuff. Whether it may prove to be successful or unsuccessful, that's another story. But he attempted to cover it up.
I understand the allegation, Your Honor. Certainly, he has no ability in the future to affect in any way, shape, or form the electronic records of these very large corporations who, at least in my experience, save most of them. And Judge, finally, with respect to the issue of the issue of obstruction, I would again note that there is no allegation that he has engaged in any threatening behavior towards the alleged victim whatsoever, as per her statement.
What about the statement, have the child's mother speak to his mother? Well, that may not be a violent form of obstruction. It clearly was intended to be obstructive behavior.
Your Honor,
Not all obstruction carries with it illegality, but all obstructions are illegal.
Understood, Your Honor, but there is still no threat made there. Obviously, two mothers talking.
Really? I got to hear this. Explain that to me, Mr. Cridge, because this will be a first one for me.
I don't have a good explanation for everything that's on the 4C. What I would argue is that it does not represent a threat being made by Mr. Colbert, and that at this juncture...
But it represents an attempt to obstruct.
I understand the argument, Judge, but I would submit that in futuro, there is simply no further opportunity...
Well, that's not true.
Judge, I don't... Well, if there was contact with the victim or her family, then certainly there... But that's something that can be addressed by the court in the form of a release order that contemplates no contact, certainly. Judge, if we look at the pre-sentence report or the public safety assessment here, I apologize.
I understand. This is his first time.
Judge,
But the PSA recommends his detention, by the way.
Judge, it recommends it based solely upon what he's charged with.
Right. No, yeah, it's true. And any decision I make is not based simply on the charge. It's based on the facts.
Understood.
But Mr. Colbert has made an auspicious debut on the criminal justice stage.
Your Honor, I would simply reiterate that under the statute and under the applicable law, I believe that...
Mr. Cridge, I've been doing this every Tuesday since January 2017. I am intimately familiar with what the standards are.
Then unless the court has additional questions,
No, I
I'll
don't.
submit. Thank you, Judge.
Ms. Carbone?
Nothing.
All right, this matter comes before the court, an application for detention. This defendant, who is a paraprofessional in a school, appears to have engaged in improper sexual contact with a minor under the age of 13. It appears, based on the facts of this case, that this was not a one-off, that the incidents alleged between this young woman and this defendant took place on multiple occasions from November to December. There is strong corroborative evidence on the cell phone, video surveillance, eyewitness, and 4C, which makes the state's case in this matter extraordinarily strong. Court takes note of the fact that he is a lifelong resident of Middlesex County, that he does have some community support, though the court is a little concerned about that community support based on the incident that took place with the victim's mother, and also by the fact that this victim, during his 4C conversation, wanted the mother of the victim and his mother to have a conversation. That shows me some intent to obstruct the process. So that clearly was intended to minimize. Also noted in the evidence of the case, the police, he was aware of the investigation commencing and taking place, and he took obstructive steps by deleting items and other things. The incidents here total 6 over that period of time. As I indicated, the state's case is strong. While there is a presumption for release, that presumption can be overcome by clear and convincing evidence that there are no conditions or combination of conditions that will assure the safety of the community. In this case, I have an individual who is involved with a 13-year-old. Multiple times, there are admissions on a 4C. I'm concerned about his release to the community and the potential for potential obstruction, notwithstanding a court order, because he was under an order not to have sex with his students, and he clearly ignored that. And of that, I have no doubt. And I have no doubt, notwithstanding the vast community support here, that he ignored whatever teachings they gave him about not having sex with a 13-year-old. As a teacher and a coach. So I find that the state has rebutted the presumption for release by clear and convincing evidence that there are no combination of conditions that will assure the safety of this community, a predator of someone who engages in sex with 13-year-olds, or that will prevent any potential obstruction of justice. So, Mr. Colbert will be detained pending the resolution of this case. What that means, Mr. Colbert, is now the state has to move with some speed. You can't stay in jail forever. They have to indict you within 90 days of your arrest and has to be ready to go to trial within 180 days of your arraignment. You have a right to appeal this decision. You must do so within 7 days of today. Do you understand that? You have to say yes or no. Do you understand that? What is it that you don't understand about an appeal, Mr. Colbert? Sorry? You need to speak up. Use your teacher voice. What is it that you don't understand about an appeal?
I'll talk to my lawyer.
You can explain it. An appeal means that you can ask another judge or judges to review my work and convince them that I made a mistake in detaining you. That's what an appeal is. So you get another shot at the apple. The trick here, though, is any appeal has to be filed within 7 days of today. Do you understand that? It means you have to move with some speed. You understand that? When is his next court appearance?
It's April 15th.
April 15th is your next court appearance.